Greetings, comrades. We are discussing the white paper as presented by the South African Minister of Home Affairs. We are looking into the policy proposals, looking into the management of asylum seekers and refugees. It draws lessons, I might say, from Canada, or gives examples like how Canada is dealing with the issue of asylum seekers and the refugees. It says, I quote, the Immigration and Refugee Protection Act 2001 Canada makes provision for the Immigration and Refugee Board, consisting of the Refugee Protection Division, Refugee Appeal Division, Immigration Division, and Immigration Appeal Division, or Special Immigration Appeals Commission, as in the United Kingdom. The Canadian equivalent of the Refugee Status Determination Officers, RSDOs, is the Refugee Protection Division, RPD. This is a statutory body charged with the responsibility of taking decisions on asylum applications. In order to avoid backlogs, its members are appointed on full-time basis in terms of the Canadian Public Service Act. In other words, the RPD performs functions that are assigned to the RSDOs in terms of the Refugees Act. The RPD conducts proper hearings with asylum seekers being afforded the right to legal representation. This obviated the long, winding and tedious appeal process under the current legislative framework, with appeals taking more than 13 years. So in its proposal, the policy proposal framework, as contained in the white paper, it says the new policy framework and legislative measures will include the establishment of structures such as in Canada. The decision-making powers will be quick, and virtual hearing can be introduced at the post of entry, as in Netherlands. What normally happens under the current regime is that a person can enter South Africa. While they are in South Africa, they go to the refugee center, apply for an asylum, get granted. Or if a person stays in South Africa, even for years, which was the case with one person who was arrested while driving. This was related to us by officials in the department. While driving, right? You get this person got arrested for some traffic offense. It was at that point that it was determined that this person was not legal in South Africa. But because the person said was applying for asylum, he could not be deported because he had made such a claim. But here, what it says, when you enter into South Africa and you are seeking asylum, your case must be heard at the port of entry. This is what here they are saying, that the decision-making powers will be quick, and a virtual hearing can be introduced at the ports of entry, as in Netherlands. In the most of cases currently, under the current regime, people keep on renewing the asylum document over the years. Some people have had it for 10, 13 years, the asylum document. Someone tell you that I was granted an asylum document in 2009, and up to now they are using the asylum document. It keeps on being renewed. But the asylum document in itself is not a refugee status, because you get to be granted an asylum document on arrival because you are running for your dear life, whether it's political or whatever reasons might be. You are granted an asylum document so that you cannot be deported while the receiving country, in this case South Africa, assesses your submission. Because when you apply, you make a written submission in the most cases, or your submission is recorded, so that it affords the South African government, through the Refugees Center or the department, to assess your claim that you are making. If it is found that your claim is genuine, then you are granted a refugee status. But if it is discovered that your claim is not genuine, You then get rejected, you appeal. Once the appeal is over, you are expected to go back to your country of origin. So here it says this decision must be quick, as in the case in Netherlands, where virtual hearings would be considered. Of course, it then says consideration will be given and provided for in the new integrated legislation to appoint either serving judges or retired judges or senior counsel as chairpersons of the appeal bodies. The new structures and a highly qualified persons to serve on them will assist in fast-tracking the asylum process. The unacceptable state of affairs in which asylum seekers who do not deserve to be granted refugee status sojourn in the country for a long period. For instance, our experience, which we have seen, is that someone will be using an asylum as a permit, so as a work permit, so to speak, and this person is not a political victim, is simple an economic migrant. Economic migrants, by their nature, they are not supposed to be granted an asylum document, but because people do not qualify for other permits, then they take advantage of the asylum document. And this is what this white paper seeks to address. It then, if you read in the white paper, paragraph 42.4, it talks about migrants or asylum seekers that you remember that were camped in Brooklyn, in Pretoria, Central Methodist Church in Cape Town, when they lost a court case. Some of what is interesting is that one of the leaders of the people, or those migrants or asylum seekers, was deported back to their country of origin in the Democratic Republic of Congo. On arrival in the Democratic Republic of Congo, the person then registered a political party to contest elections. So, because the argument when they were occupying the Methodist Church in Cape Town and in Brooklyn Street in Pretoria was that if they are deported to their countries of origin, their lives will be in danger. So the department here through this paper says that was not the case because one of the leaders then registered a political party to contest elections in their country of origin, and nothing happened to them. It then talks of the different treatment of refugees. It says, in instances of unlawful entry into the Republic, an additional requirement must be introduced that they must show good cause for their unlawful entry or presence. The minister should be empowered to declare an asylum claim made by an asylum seeker who has a connection to a first safe country invalid. In other words, the first safe country principle must be strictly applied. This will include a person who may apply to be recognized as a refugee in that state. What is this safe country principle, which the white paper is talking about? If, say, you are coming from East Africa, let's say Uganda, to get to South Africa, you certainly pass through other countries. So the question which has been raised here is that a person must show good cause why they could not sojourn in the neighboring country. Say you are from Uganda, maybe the neighbor is Rwanda. Why didn't you seek refuge in Rwanda? Why did you decide to seek refuge in South Africa? Why did you skip these countries? Was it not safe? What we've also come to understand from our experience working with the migrants is that there's also what is called internal migration. For instance, if a person in Zimbabwe is a political victim in Bulawayo, what we have come across, the department will say, okay, you were threatened in Bulawayo by people in your ward or ward in Bulawayo. What if you went to Mdare? Was your life going to be in danger if you relocated to Mdare or Victoria Falls before thinking of skipping the country? So these are the kind of questions that when one applies for asylum documents, they have to satisfy the department to say, yes, I reside in Bulawayo in Magwegwe, a political activist. I'm being intimidated, my life is in danger, and the question would be, what if you move to Gweru, or you have moved, what if you had moved to Gweru, Kwekwe, or even Harare? Was your life going to be in danger? So then in this case, in the first safe country principle is, yes, you have serious challenges in your country of origin and your life is in danger, but now you have skipped to your neighbor, which is to your neighbor, which is not South Africa, because you are far from South Africa. Why didn't you apply for asylum in that country and also a refugee status? But that does not, this first country principle does not apply to South African neighbors, be it Zimbabwe, because Zimbabwe, Mozambique, Botswana, Lesotho, Eswatini, Mozambique share a border with South Africa. But certainly Zambia, Malawi, Tanzania, and others do not share a border with South Africa, meaning that if you are coming from Tanzania, then there is a country that you get into before you come to South Africa. So the question would be, why would you want to come and claim asylum status, or refugee status in South Africa as opposed to the first country? Then it says this is an important principle which must be applied. That is the principle being the first country principle. The government is fully entitled to enact legislation in this regard, as the case in Australia. This policy framework would discourage asylum seekers who deliberately fail to apply for asylum at the safe country, which is a signatory to the 1951 Convention, the 1967 Protocol, and the 1969 OAU Convention. Furthermore, it will deter economic migrants who come to South Africa disguising as asylum seekers. If the first country principle is applied, the difficulties encountered in the case of 22 Afghan nationals would be a thing of the past. Remember, remember the issue of 22 people from Afghanistan who were said to have flown to Zimbabwe, landed in Harare, then they traveled by road to South Africa. So the question was, why didn't they apply for asylum in Zimbabwe as opposed to then driving to South Africa? You remember that it went to court, and I think the department lost and the people were allowed in South Africa. But this is what the white paper is proposing. The objectives of the refugee policy framework are to ensure that genuine refugees are recognized, legislative loopholes that allow persons without a legislative legislative loopholes that allow persons without a legitimate asylum claim will be closed. Furthermore, legislation will provide for effective monitoring of asylum seekers awaiting the outcome of their applications to avoid the high number of asylum seekers who just disappear without trace. The paper also tries to shed light on the number of asylum seekers and refugees that are in South Africa. When we were reading through, some organization had claimed that there are more refugees or asylum seekers in South Africa than in any other country. No, it was saying there were less in South Africa. So through this paper, a white paper, the department says no, that is incorrect. It says as of December 2023, the figures are 113,007 for refugees granted the refugee status in South Africa. That is as of December 2023, and 81,086 active asylum seekers and 828,404 active asylum seekers. The inactive asylum seekers refers to those who were issued with asylum permits and later disappeared into thin air. There are many people that were granted at some point asylum papers and they have not been able to renew, and the department through here says they disappeared into thin air, and says they have not renewed their permits, and the Department of Home Affairs has no idea as to their whereabouts, thus making a total of 1,334,174 of asylum seekers and refugees in South Africa. I know that you are reading this white paper, In our next video, we'll talk about the proposals on citizenship. You might have your comments. Please write your comment in the comment section. Like this video, share and subscribe to this YouTube channel. If you're on TikTok, please do follow us. Otherwise, goodbye.